Good afternoon. I see Indian Government and Politics BPSC 132 course ko Block 3 gi Unit 9 by institutions kita mamangda legislature, executive, aduga ngasidagi judiciary ko institutions maruina ahum zidi hada na pagi India da laiba democratic political system sida yamna maruiba pagi tholang ngoba aduga institutions ahum ni Dana mathang munang nai na chathar pai matung na ngasi judiciary ko unit 9 gi ngasi ko emo ha masaru ko yani ko ngasi gi judiciary saruk se adana judiciary ji karino magi thodang na karino democratic society ma democratic politics si makhata na pagi leba nga pa chathar bada judiciary gi thodang sina kamaina kayani mating pamge habadune apna naina desi ko ana hamba wa hawdok da Functions of rule making, rule enforcement, and rule interpretation are separated into the three institutions: the legislature, the executive, and judiciary under a constitutional government. Constitutional government havadi nasagi constitution amagi makada lengak pathap ama pagi ai boina leiyawi constitution si ai boina leitab suyawi adubu Constitutional government ama haira gati magi sana kangon sana pathap kharagi makhada salaiba adumba lengak pagi kon sana bi leiba adumba lengak haidare pagi constitution gi sana pathap ki makhada lengak pagi adumba lengak pathap sana ba leiba tu da koi gi rule semba kon rule making rule semba sana kangon semba rule enforcement madubu ngana ilan ba ida miyam na ba enforce to ba majisanan ba aduga rule interpretation haiba rule si karai da sumi karai da lali haidana karma matamda rule si hoigi masida violate tawi tawte hamna singbagi sugumba hoigi while ba iba interpret to ba ding sai gi hoigi madu hoigi handok pa haida ne interpretation je adubu masi matang sida akoina haida isina rule si sumi lali Masi matang sida haidana kogi madugi YNP but haitare ko mai tawdana haiba myamsi maroiba institutions ahum legislature executive and judiciary sina sigi mathawdang sing je pangse kogi function sing se ko rule making na legislature na ni rule enforcement na executive ni aduga rule interpretations na judiciary na tawyabani institutions ahum sina ko masa khaina ahum thona khaido A judiciary that is independent of and acting as a check on the arbitrary exercise of legislative and executive power is an essential feature of a constitutional government. A judiciary that is independent of and acting as a check on the arbitrary exercise of legislative and executive power. The highest institutions ahum leibasida koigi yosabi makhong ahum aibadare koigi democratic polity magi Constitutional government ki labam thokpada legislature ne executive ne judiciary ne labasida legislature na su rule semba kanda law semi mi hadana law je pangsem semba yade ko adagi mu semi ba law ji niyom sumna hoyi ko enforce to ba masina executive ki role ni adana executive na su rules je enforce to ba kanda sai ka henzen ba jare ko magi enforce to ri mi hadana rule du Sanahali Vinayadana Madugi Mamingda, Pagi, citizens singi, Magi fundamental rights, liberty, Pagi, post away Adaba. Aya Kai PB Adaba, Pagi, Pagi, Miogi, Kamam Topa, Haxin Se, Masida Aya Kaiba, and a putting the Pakanda. Sagi judiciary zina, Maduda Yade, Madu Tawayani Yaro, have nothing Magi. Ayat ba thing ba ko piba either a sect of madubu yingsin ba ko madu ida magja judiciary is ke do ba independent wa ba masang na legislature dagi executive ki power sing dagi judiciary is independent point labam sang na maram di kai gumba executive ki power ma ka do judiciary lagi ta executive na to ko di ma judiciary is na loine in the are adi ta di ngasagi constitutional government ama lagi kana ba ju do pa lai ro ai executive na arbitrary washalaga de bai de toning ba toraga di ko adana ngasai constitutional government amagi magi leibam thokpa chang da ya da ba koi gi mawong mato ma hairaga di judiciary independent wa ga da bani aduga loina na legislative amasung executive branches singina organs of the government sina aranba ahenba thabak tawhoidaba thabak tawrokpa kanda maduda yadi aidana madugi wayat piba haidare ko madu ngamgadobne. The judiciary is also the final arbiter of what that constitution means. Constitution I will see iraga natraga idana leiba kogi lengak ngakpagi sana pathap singbu yawbo warol haidare ko madugi doni akoina khanarese constitution je adana constitution masamaksi lebam da sanariba se India da sanariba constitution si masigi provisions me amsi masi kamaina madi wahan thopi gani madu karaida semdokpa mathau tai adagi madu executive na lana interpret tawbra habna simbagi punama ko masigi final kainosi arbiter di madugi asumarangi while people see judiciary na p and constitution ki provisions legal interpretation haibam lapani na provisions in the yauriba post dagi ka henjanna power season aba yanaba executive na natraga legislature na moya tawise summi haibagi mongda constitution ki provision ki wangmada ahen mathaba tawrona bohona baganda judiciary na madu yade sumila le hojigi magi while simana piyebu. Given the federal system prevalent in the Indian political system, the judiciary also serves as a tribunal for the final determination of disputes between the union and its constituent units. Adagi amna maru eba mana judiciary ki magi functions ko role and functions ki kanos data koigi India da lazy koigi quasi federal system ko federal structure na koigi USA ki kari laiba sugumagi pra kano masubatawa koigi federal ki structure the yawa ngasai center ki state ki ko dagi ngasai mamang su kano nainagre center state ki union list state list concurrent list kind of power sharing ki kari ki mai ko resource sharing ki mechanisms me ama yawa ni na India ki laiba political system si constitution ki matung ina federal structure ma yawa ya besti ko na kakpa yadra wafam ni aduna laiba federal ki sana pathap sigi manung sidaida judiciary na asai yamna maruiba while tawnana bagi maruiba thodang amasu lawri karamba matangda ka for the final determination of disputes between the union and its constituent units asai union and its constituent units India da laysi union government or central government hadana ma lere aduga atopa states mayam jigi magi federal unit side reba state ki laiba government sing ko adana ani jigi marakta central government amasung state government ko ani gi marakta kaigumba mungnaba wathok ama lagpa kanda madugi asum arangi while si kanana lepodage kanda judiciaries na lepana. Thus, importance of the role and functions of the Supreme Court and High Courts demand ensuring independence of the judiciary. Adana masai haiba maruina kharapalliba judiciary magi mathaudang ko mana loriba thaudang adu magi mathausing aidare ko masi Supreme Court na ko High Court na sai yingsen gedori bani sai kaino me amsida ko judiciary kaino system se adana Supreme Court na highest court of appeal weraga makata bada state singi na High Court silai adana high ba Supreme Court so High Court sina sai gi tawriba thabak thoram mai koi gi thodam me amsi aduki matik maru oidu yengora kanda mai koi se maning makhatamna haibadi legislature amasung legislative body aduga executive body dagi moise maning makhatamna khutjingjalan da bidan lahen basi am mathau tarak adagi mathang da koina judiciary se koina hoji highest court of appeal oina India gi da laise Supreme Court ni mathang da koi state ki level da koi High Court sana myam lai ba ꯉꯁꯤꯗꯤ ꯍꯧꯖꯤꯛꯇꯤ ꯃꯅꯤꯄꯨꯔꯒꯤꯁꯨ ꯃꯁꯥꯒꯤ ꯁꯦꯄꯔꯦꯠ ꯑꯣꯏꯕ ꯍꯥꯏ ꯀꯣꯔꯠ ꯑꯃ ꯂꯩꯈ꯭ꯔꯦ ꯃꯇꯝ ꯑꯃꯗ ꯑꯩꯈꯣꯏꯒꯤ ꯒꯨꯋꯥꯍꯥꯇꯤ ꯍꯥꯏ ꯀꯣꯔꯠꯀꯤ ꯃꯈꯥꯗ ꯑꯩꯈꯣꯏ ꯕꯦꯟꯁ ꯈꯥꯏꯗꯣꯛꯑꯒ ꯑꯗꯨꯃꯥꯏꯅ ꯂꯩꯔꯝꯃꯤꯀꯣ ꯑꯗ ꯉꯁꯥꯏꯒꯤ ꯖꯨꯗꯤꯁꯤꯌꯔꯤꯅ ꯉꯁꯤ ꯏꯟꯗꯤꯌꯥꯗ ꯂꯩꯔꯤꯕ ꯖꯨꯗꯤꯁꯤꯌꯔꯤꯒꯤ ꯁꯛꯇꯝꯁꯤ ꯃꯥꯒꯤ ꯏꯟꯁꯇꯤꯇ꯭ꯌꯨꯁꯟꯁꯀꯤ ꯁꯛꯂꯣꯟꯁꯤ ꯉꯁꯤꯃꯛ ꯂꯩꯕ ꯁꯨꯃꯥꯏꯅ ꯍꯥꯟꯅꯗꯒꯤ ꯁꯨꯝ ꯂꯩꯔꯛꯄꯗꯤ ꯅꯠꯇꯦ ꯃꯥꯒꯤ ꯍꯧꯔꯛꯄꯒꯤ ꯍꯧꯔꯛꯂꯣꯟ ꯍꯥꯏꯕ ꯇꯥꯔꯦꯀꯣ ꯏꯚꯣꯂꯨꯁꯟ ꯃꯥꯒꯤ ꯁꯨꯝ ꯃꯄꯨꯡ ꯃꯔꯩ ꯉꯁꯤꯒꯤ ꯂꯩꯔꯤꯕ ꯁꯛꯂꯣꯟ ꯁꯛꯇꯝꯁꯤ ꯑꯣꯏꯔꯛꯄ ꯐꯥꯎꯕꯒꯤ ꯃꯥꯒꯤ ꯋꯥꯔꯤ ꯁꯤꯡꯕꯨꯜ ꯑꯃ ꯍꯥꯏꯕ ꯇꯥꯔꯦꯀꯣ ꯃꯗꯨ ꯑꯃꯨꯛ ꯅꯩꯅꯁꯤ Evolution of the contemporary judiciary in India can be traced to the colonial period. ꯑꯍꯥꯟꯕ ꯃꯛꯇꯗ ꯑꯩꯈꯣꯏꯅ ꯈꯪꯒꯗꯕꯁꯤ ꯖꯨꯗꯤꯁꯤꯌꯔꯤ ꯉꯁꯤ ꯏꯟꯗꯤꯌꯥꯗ ꯂꯩꯕ ꯖꯨꯗꯤꯁꯤꯌꯔꯤꯒꯤ ꯁꯤꯁꯇꯦꯝ ꯑꯁꯤ ꯃꯥꯒꯤ ꯍꯧꯔꯛꯄꯒꯤ ꯋꯥꯔꯤꯁꯤ ꯊꯤꯒꯠꯂꯨꯕ ꯀꯥꯟꯗ ꯑꯩꯈꯣꯏꯒꯤ ꯕ꯭ꯔꯤꯇꯤꯁ ꯀꯣꯂꯣꯅꯤꯌꯦꯜ ꯄꯦꯔꯤꯌꯗꯀꯤ ꯃꯇꯝꯗ ꯃꯗꯨꯗꯒꯤ ꯑꯩꯈꯣꯏ ꯍꯧꯕ ꯇꯥꯏ The Regulating Act of 1773 gave birth to the first Supreme Court in India. ꯑꯍꯥꯟꯕꯒꯤ ꯑꯣꯏꯅ Regulating Act of 1773 ꯁꯦ ꯃꯁꯤꯗꯒꯤ ꯏꯟꯗꯤꯌꯥꯒꯤ ꯑꯣꯏꯕ ꯑꯩꯈꯣꯏꯒꯤ ꯑꯍꯥꯟꯕ ꯁꯨꯄ꯭ꯔꯤꯝ ꯀꯣꯔꯠ ꯑꯃ ꯁꯦꯝꯕꯒꯤ ꯀꯩꯅꯣꯁꯦ ꯍꯧꯔꯛꯈꯤꯕ It was located in Kolkata ꯃꯁꯤꯅ ꯀꯣꯜꯀꯇꯥ ꯍꯥꯏꯅ ꯀꯧꯔꯦ and it consisted of Chief Justice and 3 judges subsequently reduced to 2 judges ꯑꯍꯥꯟꯕꯒꯤ Regulating Act of 1773 ꯒꯤ ꯃꯈꯥꯗ ꯁꯦꯝꯒꯠꯈꯤꯕ ꯁꯨꯄ꯭ꯔꯤꯝ ꯀꯣꯔꯠꯀꯤ ꯀꯩꯅꯣꯁꯤ ꯀꯣꯜꯀꯇꯥꯗ ꯕꯦꯁ ꯇꯧꯏ ꯑꯗꯨꯒ ꯍꯥꯏꯔꯤꯕ ꯀꯣꯔꯠꯁꯤꯗ ꯂꯩꯔꯤꯁꯦ ꯆꯤꯐ ꯖꯁꯇꯤꯁ ꯑꯃꯒ ꯖꯖꯦꯁ ꯑꯍꯨꯝꯒꯅꯤ ꯑꯗꯨꯕꯨ ꯀꯣꯟꯅꯊꯪꯗ ꯖꯖꯦꯁ ꯑꯅꯤꯗ ꯍꯟꯊꯍꯜꯂꯛꯈꯤꯀꯣ They were appointed by the crown and it was made king's court rather than a company's court ꯑꯗꯨꯅ ꯍꯥꯏꯔꯤꯕ ꯀꯣꯜꯀꯇꯥꯗ ꯕꯦꯁ ꯇꯧꯕ ꯁꯨꯄ꯭ꯔꯤꯝ ꯀꯣꯔꯠꯁꯤ ꯑꯩꯈꯣꯏꯒꯤ ꯀ꯭ꯔꯥꯎꯟꯒꯤ ꯀ꯭ꯔꯥꯎꯟꯅ ꯆꯤꯐ ꯖꯁꯇꯤꯁꯁꯨ ꯖꯖꯦꯁ ꯉꯩꯗꯨꯁꯨ ꯑꯄꯣꯏꯟ ꯇꯧꯕ ꯃꯣꯏ ꯊꯕꯛ ꯍꯥꯞꯄꯁꯤ ꯀ꯭ꯔꯥꯎꯟꯅ ꯕ꯭ꯔꯤꯇꯤꯁ ꯀ꯭ꯔꯥꯎꯟꯅ ꯍꯥꯏꯕꯗꯤ ꯅꯤꯡꯊꯧ ꯕ꯭ꯔꯤꯇꯤꯁꯀꯤ ꯅꯤꯡꯊꯧ ꯅꯠꯇ꯭ꯔꯒ ꯃꯣꯏꯒꯤ ꯅꯤꯡꯊꯧꯔꯦꯜ ꯅꯠꯇ꯭ꯔꯒ ꯑꯩꯈꯣꯏꯒꯤ ꯂꯩꯃꯔꯦꯜ ꯍꯥꯏꯕ ꯇꯥꯔꯦꯀꯣ ꯃꯍꯥꯔꯥꯅꯤꯁꯤꯅ ꯉꯁꯥꯏꯒꯤ ꯊꯕꯛꯇꯣ ꯍꯥꯞꯄꯤ ꯑꯗꯨꯒ ꯍꯥꯏꯔꯤꯕ ꯀꯣꯔꯠꯁꯤ ꯏꯁ ꯏꯟꯗꯤꯌꯥ ꯀꯝꯄꯅꯤꯒꯤ ꯀꯣꯔꯠ ꯑꯣꯏꯕꯒꯤ ꯃꯍꯨꯠꯇ ꯀꯤꯡꯁ ꯀꯣꯔꯠ ꯑꯣꯏꯅꯀꯣ ꯀ꯭ꯔꯥꯎꯟꯒꯤ ꯃꯈꯥꯗ ꯑꯗꯨꯃꯥꯏꯅ ꯂꯩꯔꯝꯃꯦꯕ The court has jurisdiction over His Majesty's subjects wherever the Supreme Courts were established ꯑꯗꯨꯅ ꯉꯁꯥꯏꯒꯤ ꯀꯣꯔꯠꯁꯤꯒꯤ ꯃꯥꯒꯤ ꯖꯨꯔꯤꯁꯗꯤꯛꯁꯟ ꯃꯥꯒꯤ ꯃꯊꯧ ꯃꯉꯝ ꯃꯥꯅ ꯑꯩꯈꯣꯏꯒꯤ ꯌꯦꯡꯁꯤꯟꯕ ꯌꯥꯕ ꯃꯥꯒꯤ ꯋꯥꯌꯦꯜꯒꯤ ꯄꯥꯡꯈꯩ ꯍꯥꯏꯇꯥꯔꯦ ꯃꯥꯅ ꯋꯥꯌꯦꯜ ꯇꯧꯕ ꯌꯥꯕꯒꯤ ꯄꯥꯡꯈꯩ ꯅꯨꯡꯁꯤ ꯀꯗꯥꯏ ꯐꯥꯎꯕꯅꯣ ꯍꯥꯏꯔ ꯀꯥꯟꯗ His Majesty's subjects ꯍꯥꯏꯗꯤ ꯉꯁꯥꯏꯒꯤ ꯕ꯭ꯔꯤꯇꯤꯁ ꯀ꯭ꯔꯥꯎꯟꯒꯤ ꯃꯈꯥꯗ ꯑꯩꯈꯣꯏꯒꯤ ꯕ꯭ꯔꯤꯇꯤꯁ ꯑꯦꯝꯄꯥꯌꯔꯒꯤ ꯃꯈꯥꯗ ꯂꯩꯕ ꯑꯩꯈꯣꯏꯒꯤ ꯃꯤꯑꯣꯏꯁꯤꯡ ꯍꯥꯏꯇꯥꯔꯦ ꯃꯇꯝꯗꯨꯗ ꯑꯩꯈꯣꯏ Majesty's subjects ꯍꯥꯏꯁꯦ ꯁꯤꯇꯤꯖꯦꯟꯁ ꯑꯦꯟ ꯁꯕꯖꯦꯛꯁꯀꯤ ꯗꯤꯐ꯭ꯔꯦꯟꯁꯇꯨꯅꯤꯀꯣ Citizens ꯍꯥꯏꯔꯒꯗꯤ ꯃꯈꯣꯏꯁꯦ ꯀꯔꯤ ꯍꯥꯏꯅꯤ ꯃꯁꯥꯒꯤ ꯐꯟꯗꯥꯃꯦꯟꯇꯦꯜ ꯔꯥꯏꯠꯁ ꯑꯗꯒꯤ ꯃꯥꯒꯤ ꯐ꯭रीडम ꯂꯤꯕꯔꯇꯤ ꯀꯌꯥ ꯑꯃ ꯑꯩꯈꯣꯏꯒꯤ ꯐꯖꯅ ꯑꯦꯟꯇꯥꯏꯇꯜ ꯇꯧꯔꯀꯥꯟꯗ ꯃꯥꯒꯤ ꯀꯔꯤ ꯍꯥꯏꯅꯤ ꯆꯞ ꯆꯥꯕ ꯂꯩꯕꯥꯛ ꯑꯃꯒꯤ ꯃꯤꯑꯣꯏꯅꯤ ꯍꯥꯏꯗꯅ ꯂꯩꯕꯥꯛ ꯃꯆꯥ ꯑꯃ ꯑꯣꯏꯕꯒꯤ ꯃꯥꯒꯤ ꯑꯦꯟꯇꯥꯏꯇꯜꯃꯦꯟ ꯀꯌꯥ ꯑꯃ ꯄꯤꯀꯣ ꯑꯗꯨ ꯐꯪꯗ꯭ꯔꯤꯉꯩꯗ ꯑꯩꯈꯣꯏꯒꯤ ꯕ꯭ꯔꯤꯇꯤꯁ ꯀ꯭ꯔꯥꯎꯟꯒꯤ ꯃꯈꯥꯗ ꯂꯩꯔꯤꯉꯩꯗ ꯕ꯭ꯔꯤꯇꯤꯁ ꯑꯦꯝꯄꯥꯌꯔꯒꯤ ꯂꯣꯏꯂꯝ ꯃꯅꯨꯡ ꯆꯜꯂꯒ ꯂꯩꯕ ꯃꯤ ꯈꯨꯗꯤꯡꯃꯛꯁꯦ British Empire subject His Majesty's subjects are khanaiko wherever the Supreme Courts were established aduna Supreme Court linkaliba mafam khadimakta laiba saigi British Crown gi magi loilam makhada laiba mioi singdo moigi masakta wire sathana ba maina linkatkhibane Supreme Courts were established in Madras masigi Chennai first and in Bombay Mumbai later ahambada Supreme Court se atai da su linkali Madras da dagi Bombay da During this period judicial system were divided into two systems the Supreme Courts in the presidencies and the Southern Courts in the provinces aduna haiba matam sidadi matam dugi puari thengkhang se phawda di lairamiba judiciary gi while loisang gi magi Kangon haiba kare mai mo matausi kamaina ani thona khaido lerami ahamadana Supreme Court saidana presidencies hoigi British na kano toroga loksalaga leiba India gi tongan tongan mafam singsi ngasai gi magi provinces haiba adagi presidencies haina magi administrative kano haitare bai khenaba ranking da maina lerami presidencies ngaidana kedoba Supreme Court linkalami aduga provinces singdana hoigi provinces haibje ngasi gi hoigi states haibajini maina provinces ngai Southern Court side na linkha leba magi keno se thar se khenai ko hierarchies Supreme Courts in the presidencies follow the English law and procedure, while the latter follow regulation laws and personnel laws. Adana Supreme Courts presidencies in the Linkaliba Supreme Court sidi ngasai English ki law, English ki kayani lebang nga pagi kanon sing aduga magi mo mato sing haidare pa madu paisa nei ba aduga Sadar Court sing dina sagi regulation laws and personnel laws saidana pagi mafam dogi lenga ko ga mari leina ba ko pagi adugumba kanon sing degi magi kanglup tugi magi chana ba ko adugi keno sing che chana lam. These two systems were merged into one under the High Courts Act of 1861. High ba Sadar Courts, the Mathata Supreme Court, and presidencies of the provinces, Kimatungina, Kaido Galerambasi, Amato in Amukamutam, the High Courts Act of 1861 in Makada, system and Isipula Punsalem. This act replaced the Supreme Courts and the native courts. With Sadar Diwani Adalat and Sadar Nizaman Adalat in the presidency towns of Kolkata, Bombay, and Madras with high courts. Then Haiba, the key Exigi Makada, Supreme Court Mamse, Aduga native courts in Se, Kedova, presidency towns in the Leramba, Kolkata, Bombay, Madras, Mamse, high courts and way more significant. The highest court of appeal was the Judiciary Committee of the Privy Council. And the highest court of appeal is quite a wamba, Pagi, Asum Arangi, Wild Torpakanda, Asagi, Matang Honorable, quite a wamba, Hakale Pagi, Asumba, Wild Pin and Nava, Laivanosi, while Washangi Makoksi, Privy Council, not where I'm never Matamula. For the first time in the history of the Indian legal system, it marked the beginning of a new era in the emergence of a unified court system. Adana Indian legal system ko India gi langa karon ga mari leinaba mo mari nama sangalapagi puari sida pagi yana loina apunba India yu ba unified court system ama Gadi violation gi punba saktam mama salon among asaki yana loina safong paze hariba matam sida waiki. The Federal Court of India was established in Delhi by the Act of 1935. The Mahatarapada Sagi Act of 1935 and Napagi Amaruba India Constitution gi Magi evolution ga mari laina ba Yam Maruba sing as in Masana river constitution Ziki I am a Saru my Momoto si Hariba Act of 1935 Masigi can Masika Sui am Marila Navani and then Sigi Makada Federal Court of India Haidana Delhi Malinkat The Federal Court of India was to act as an intermediate appellant between the High Courts and the Privy Council regarding matters involving the interpretation of the Indian Constitution. Adana Saigi Federal Court of India C 1935 Linkatpagi Wafamsi Tola Pakanda Masikari Maru no Haragadi High Federal Court of India Sina Saigi Ladiba High Court Simpa Adi Mwatuamba Yagi Wafam Sinda Hana Lerba violation systems in Mutakar Matunda highest court of appeals in the Privy Council Warakanda Makha Tabda Saigi high courts Mamalin Kalea and Mamanda Pancrepa. The high courts in Siga Privy Council Siga Ani Marata Koigi Wailgi Subli Privacy Federal Court of India is no way. I Privy Council by the highest way Adu Matata Privy Council Yosinada High Court in Sigi Matakta Federal Council of India Silay. Aduna Masina, Kari Maru, Matodang Logi Havaganda Sagi, then Constitution, give Magi provisions, managing interpretation, In addition to this appellate jurisdiction, the Federal Court has advisory as well as original jurisdiction in certain other matters. Haiba, Sagi, Anidugi Marakta, Federal Court of India, Sagi. Wailgi Tafo Tasenko Jumaran Jinsin Bagi can Osiki Matakta Bedre Kosiki Magi Pongan Batai Matodang Sing Haragati Magi advisory role Poktapi Bagiko Aduga Topa Magi original jurisdiction Naidana Paisumba Pongan Tongan Bow of Hamsing the Magi Matodang Sing later. This court continued to function until 26 January 1950, the day the Indian Constitution came into force. The Federal Court of India Act of 1935 ki makada sengwatkriba court siki magi mapunsi haibtare masi karai phawba lairamge haiba kanda India ki constitution si sanaba horakiba ka India se republic ama horakiba 26 January 1950 ka sidi matansi bawa Federal Court of India se koi mathau pangthoga lairamne. The Supreme Court Supreme Court, the entire judicature has been divided into three tiers: Supreme Court, High Court, and Sessions Court. Adana India ki hujik laiba koi judiciary ki magi system si koi ki thagum khaiba three tiers ka thagum khai pai matak the Supreme Court lare matak the High Court lare aduga hum subdana amu ka Sessions Court lare ka. The Supreme Court is the highest court of law. The Constitution says that the law declared by the Supreme Court shall be binding on all small courts within the territory of India. And the Supreme Court is not quite the highest court of appeal. Mana lepradi magi ware magi verdicts in a final ni. Adana Constitution hari madudi Supreme Court na. Asagi atopa makathawa apekpa courts ka High Courts ko gira Sessions Court ko gira ate Mayam sida mana kayani lepakpa law ko Supreme Court na lepakpa law sina law na mag court tay makata ba mayam sida law na binding way badi madu nga na sa tatkado ni aidano ko idagi ngamkhay ko idari ba sige ngamkhay nung dalay ba wagi while basangi topa basang mayam se hadare ko masi Supreme Court na Pirakpa magi waretuna waretuloi illaga sakadawuna. Below the Supreme Court, the High Courts are located in the states. Under East High Court, there are district sessions courts, subordinate courts, and courts of minor jurisdiction, that is called small courts. Under High Court, state ki level the lare aduga state ki manung sida haidare mo makhata rakpada High Court ki makhata rakpada district sessions court, subordinate courts, and masang people while the Watolan toxins while being another while the Supreme Court was designed to make it the final authority in the interpretation of the Constitution. Now, Supreme Court the highest court of appeal or my highest court of law, highest Constitution, Indian Constitution see my provisions in system parakpakanda amaga Mugnabugumba, Amaga, Kara, Sarak Sahing Nabagi Monga, Tolopra Matang Yaw of the Tepa, Constitution, Siamna, Tava, Lenges Weba, Dumba, Provisionski Ayawanina, Madu Amaga, Munarapa Yenarapa, Tolopakana, Madu Kamaina interpreter Wuni, Kamaina Madu Hangani, legal Giwepa interpretations of the Kamaina Hangani Havagi, Wapam Jila Paganda Masiki, final authority. Iroiba. What if Masikana Mokotela Yavakanda, Supreme Court, Supreme Court is powerful weather. While framing the judicial provisions, the Constituent Assembly gave a great deal of attention to such issues as the independence of the courts, the power of the Supreme Court, and the issue of judicial review. And then Constituent Assembly Saigi Canada never me amatoki debates Kiamatoki, Masigi, Constituent Assembly, Mifam Kiada, Hogi Kanagiba, Maru in the judicial provisions kiko, while Marilenaba, while Toda, Marilenaba, Wafam Singsi, Semapakandaka, Yam Maruina, Hogi, Puning Wakanka, some Nakanatogi, Sikari, Matanda, Nohakana, independence of the courts, courting seat, Sagi legislature, Amasung executive key. Kubam the Lehenda by the Maning Makatamba, Wahemba, and the Supreme Court Kimagi, Matimangam, Adoga Lena Doina Namasagi, judicial review, Haribasingasi, Amaru Oye, Masi Yauda Yandi, and the Constitution, judicial provisions since the Constituent Assembly, the minor, we have key have done. When a Masini Amaru was a judiciary, Amaru was this later Constituent Assembly. The best camera is so called Mami Sound and Taikon, Marina judicial provisions since you're going to name a propaganda. Was it more going on judiciary by institutions? Institution, one of the important institutions my composition and appointments karino ko aduga maikoi thodang puriba pham haidare ko phamdo ma'am si kana na koi thabak se khanbagi habagi kaino the Supreme Court consists of the Chief Justice of India and not more than 26 other judges ko Supreme Court si Chief Justice of India sina mana makok ta leirakanda ko koi yamabada 26 ka atopa judges kuntaruk tagi henba yadre habani kuntaruk tagi hendaba ka judges atai myang pullaga koi semane Chief Justice of India ne aduga koi judges kuntaruk tagi hendaba ka judges ni ka pullaga ka it had only 8 judges when inaugurated ka hamba Supreme Court se hogo pakanda judges se nipan khadang lairam yarani The President of India, who is the appointing authority, makes these appointments on the advice of the Prime Minister and the Council of Ministers. Prime Minister of India and the Council of Ministers ki pautak makada pautak laura matunda President of India na hariba Supreme Court ki Chief Justice of India and the judges ma'am se ba magi koi je khal level. The Constitution stipulates in Article 124 Clause 2 that the President shall appoint judges of the Supreme Court after consulting other persons besides taking the advice of his ministers. Constitution Article 124 Clause 2 the high President judges after consulting other persons besides taking the advice of his minister. At the Council of Ministers Prime Minister and his Council of Ministers experts President judges kanana Chief Justice final decisions For appointing the Chief Justice of India, the President shall consult such judges of the Supreme Court and High Courts as he may deem necessary. Prime Minister and the Council of Ministers ki pautak lobo khatana tana koi consult to khatana tana Chief Justice of India si kana ohengedagi haidana khalakpu kanda President sina mana Supreme Court ki tai judges sing aduga High Court ki judges sing ka mana mathau taina khalagadi ka mana moi myang si ju mawata ga ne haidare ka kana na ohemda In spite of this clear constitutional provision, the appointment of the Chief Justice of India has become a matter of political controversy. High constitutional provisions in Kamaina, President of India, Supreme Court, Chief Justice of India, the judges may see Kangani, Kotkani having a single of constitution. Chief Justice of India, Chief Justice of India, the Kanbagi Matang political political could sum up by the Many issues were raised in 1973 when the government of India appointed Justice S.S. Ray as the Chief Justice of India, superseding 4 other judges against the recommendations of the outgoing Chief Justice S.M. Sikri. Haiba controversy, political controversy, Namatoi, and the Topazing Manunda, Maruiba controversy, in 1973, Justice S.S. Reyes, Chief Justice of India, Wina, Kanma Matamda, Atopazes, Marie, Kanto Maganda, Maze Kalapaganda. So, what's one talking? Haiba Justice S.S. Reyes, outgoing Chief Justice Mamanga Chief Justice SM Sikri Mana Piramba Warol Singh Mana Sumai Toganas Mana Silimi Sina Oivna Pai Silimishina Oiva Pai Haidana Magi Pongamba Kayumakara recommendations Karako Warol Pirambado Madugi one of the Navada Masagi SS Reyes 1973 the country so what more here. To avoid political interference in the appointment of judges of the Supreme Court, some important qualifications have been set for the post, such as political interference, Sambam Toktaba political Kutsang Havani, Kutin and Bagi Wafamasi, Maruina Supreme Court, Chief Justice of India, Dugazazi Singh Kanway Matangani, and a higher man Sita Kara Makai Hadarana Bahaidarima. The interference still lay later Sumadukra Safana with the Marta, High Bazazis Mamsi, Magi Monda, Sien Gadaba, Magi Kayani, Magi Matik May I sing, Magi Wagadaba. Legadaba kano mati may sing either badu koi kharapiri amada eda a person should be a citizen of India masidi suso soidra judges soidra Supreme Court judges soidra mio edu India citizen oidra ni be the judge of the High Court for at least 5 years. High Court amada yamra sahi manga thabak tora judge ma oidra ni Sida or should have been an advocate of High Court for at least 10 years. Natragana High Court Amada Yamdra Sahi Tara Sahi Tara advocate or Pahidara. Dida Natragana a distinguished jurist in the opinion of the President of India. President of India Wakanda Koyam Masak Naiva while I have a jurist I was a Dumba. Legal expertise among others and while Lepada Yamna high Simbadu money Masana money and the President of India and a color with Targadi had a new Supreme Court Jesus when a Kanbada Matic Sai had an Asumina Kalatami. The collegium system of appointment of judges is also popularly referred to as judges selecting judges. The system was created by two judgments of the Supreme Court in 1990s. In the 1990s, the Supreme Court judgments anida yumpham oirkanda collegium system of appointment of judges haidana masemi saigi Supreme Court judges myam si khanbaji kamaina karama mawong matau yengkanda khangadari habagi magi madugi sana kanglon ko madugi kenoduni collegium system se ko adana masibu koigi judges selecting judges haidana khani ko judges myam semba collegium system amani madana haiba judges myam na mo judges khanbagi kenoni ko koigi mawong amani kasagi collegium systems. A body of senior apex court judges are responsible for appointment and transfer of judges of the Supreme Court and High Court. A body of senior apex court judges the senior alwarba matam sangna while I sing a tabak torba dumba High Court ki Supreme Court kari da tabak torba dumba judges myamagi mogi apunba platform ama haidare phampa ma dumba kano sina ngasai Supreme Court ki High Court ki judges sing khanbagi aduga transfer to singi ko kano sin lepe what if ko adugi body to ngasai this body of senior apex court judges is called the collegium system of appointment of judges, which is popularly referred to as judges selecting judges and the apex court singi judges singi so what thodang masu yawi habani ngasai appointment of wisdom tenure my thabak se appointment of gi wafam koi huzik naina khe mathanga koina mung laisna magi thabak se khallaba matungda matam kayam koina thabak to pugani habani once appointed as judge holds office until he attains 65 years of age thabak se he khangra matung sahi humfu manga sudri phawa just na my office continue to as judge of Supreme Court may resign from his office or may be removed in case of misbehavior or incapacity. Supreme Court ki judge ama mana magi thabak ti potha ba ha sahi humanga sudringai da ko thabak khala matung sahi humanga sudringai mama ma resign to we ai magi office ti ko natragana masi kaigumba mathong hokta thabak ko misbehavior ranba thabak tawbagi natragana magi incapacity adi magi thabak thoramda mabung phana mawong tana tawba ngamdre habagi report phangwa matungda masi thabak tai lothokpe ya. As per the constitution, each house of the parliament will have to pass a resolution supported by 2/3 of the members present and voting. And the constitution ki provision matungina parliament ki laiba house kuding na ka resolution ama pass tawdabani yamdrabada saiki session house to gi ka 2/3 members ka saro om to pagi ani ka support the wider from the Yauba, both other Miner, Saru Home Topaganina, Yaraga passed over resolution, Madugi, Matin Log and the Pagi, Judges and Lotopia have any. The device to remove a judge is known as impeachment. The first motion of impeachment against a judge was tabled in Parliament in 1991 involving Supreme Court Justice V. Ramaswamy. Saigi President of India, Lotopagi Matan, the impeachment post a panchi. Fista Adimagi Tabak retirement, larging a marathon, tenure my office bearing Peresida Kayumamase, Kayumamagi misbehavior, Natragana incapacity in this context. Sagi judges, Supreme Court judges, Tabaks again, Lotoke Haragading Sagi, Parliamentary House, Anida Sagi, two-thirds members now support over. Adumba resolution of a pastor or Tawanika. Adana Masilotope Mosizu, President Otopogi, the minor impeachment Kawi. Yana Boina in Yagi history da Wagi Sugumba Mosanama, just Lotona Bagi Pose, Karamkanda Laki Yakanda, 1991, the Supreme Court Justice, V. Ramaswamy, Mayota, minor Tankalaki. When an audit report reveals several irregularities committed by the judge during his tenure as the Chief Justice of the Punjab and Haryana High Court, a three-member judicial committee was set up with a serving and a retired Supreme Court judge and the Chief Justice of the Bombay High Court. Adana Saigi audit report ama Yengmakanda Saigi Justice V. Ramaswamy na Mana Tabak Tauring Selection by Toway the Aran Maka Tokri, Havagi report, Warosi, Tagalak by the audit report in a car. Madagidi, Masi Wahon the Solopadadi, Masagi, Haiba, Chief Justice of the, like 3 members of the Judicial Committee, Sangale, High Vista, Tabak Tawiba. Supreme Court Judge, retired Supreme Court Judge, Aduga, Chief Justice of the Bombay High Court, Masasi, Moya Humsina Pulagana Committee, Masamakana Singing Salem. The committee's findings concluded that there had indeed been a willful and gross misuse of official position and intentional and habitual extravagance at the cost of the public interest, which amounted to misbehavior. Aiba 3-member Judicial Committee na Putoreba audit reports da Moina. Panakpa Warol Singh ko Madrida when I see Justice V. Ramaswamy na mana paiba position ko masi season arakanda mana tauge yauna magi hainabi ama wena ngasagi yamna kaayana kogi muai thopa ko kogi sading to bai dare kogi ake amau ngasagi ko hawatum sugumba ko luxury ke amada kogi senjil lo shan bai dare ko sigi pona ma mana reports the tenai, but do Magi misbehavior ni Haidana Mana or the reports the Pukale. Justice Ramaswamy, however, maintained that there were procedural irregularities in the notice of the motion, the constitution of the committee, and its functioning. However, 3-member Judicial Committee, Mayoksida, Justice Ramaswamy, High Madudi, committees is Semakpagi, Magi, procedure Singdu. The Soiba around Maka, Mayawi, Aduga Loina na committee Shemagi Mo, Madu Tabako Mo Mando, Zagi Yana, Mo Tadaba, Aramba, Way has an amount of the way and Pukale. The impeachment motion, which was moved in May 1993, failed with 196 out of 401 voting for it, and the remaining 205 abstaining. Me puna sagi impeachment is ka parliament da samiga ama sing manungda president ba the vote na bada 196 na pa vote thadai aduga lemhoriba sani ga manga sina pai vote thada ba yaw da ba haidare mai tawduna 1993 me da main thoki. However, the judge eventually resigned. Impeachment motion today failed. I am masing ayamba 2/3 majority na support organda poto wa idabani adubu madu fail wa ire tabu Justice Ramaswamy masamati aduma makata na thabakti tawkhre ma ikai wadagi ni khangde nungai tabadagi khangde dumaina don resign tawkhre ba salaries uzina mu tolok ki wafam lai amaru ba wafam mani a very important element that determines the independence of the judges is the remuneration received by them. Koigi judiciary is independent when gazobani from legislative and executive control have simamang high ba aduga independent judiciary should be empowered to have a say on the activities of the legislative body as well as the executive file na mamanda pankre habidi judiciary is empowered over mathautai na independent ohebadana tuna habidani ko masigi yamna maruiba warola ma hairagadi ngasagi judges mayam si independent ohebane adana judges sing independent kamaina ohenbada kari mating season agya ganda salary ki mating season nei maramdi maikoina phangiba tolo ko makoigi service ki phangiba tolo si seasona ko yam sawa thoda ma lawa the salaries and allowances of the judges are fixed high to secure their independence, efficiency and impartiality. Judges me amjina thabak torpa kanda maikoina while torpa kanda saigi maning makha tamjanaba aki akhangba yaudana ko mina khut sinjalapa ngamdanaba hena mong tana thabak tamunaba ko aduga misang khai naidanabagi wafam je yengba kanda maikoida phangiba judges singina phangiba salaries and allowances me amja adugi mate wang tolok yam saw na pialani. Besides, every judge is entitled to a rent-free official accommodation adugi mathakta maikoida saigi thagi ko Hawaii mal bidaba official accommodation makoigi lainanaba quarter should be. The constitution also provided that the salaries of the judges cannot be changed to their disadvantage except in times of a financial emergency. And a constitution dazu masi wafam zipali madudi judges singi salary si asagi handan bayati kathaba yati haizana ko masi kathaba yawagi conditioner be madukar matamna haikanda India da financial emergency lautho sentong ifibam yamna social padagi financial emergency lautho matamda khakta maikogi salaries and allowances masida kathaba yai aduna tabaladi kathaba suya yadi adna constitution the provision piri ko all these expenses are charged on the consolidated fund of India consolidated fund of India hadna kogi diversity punba magi menwai da revenue dagi ko pai lakwa fund amani ko masigi fund sidagi asagi haiba judges singi mogi salaries ki allowances ki kanu nam se sida boinama sidagi pi dunya immunities salaries ki mathang da mo immunities everything asagi maikoina thabak se torpakanda with efficiency impartiality and independence ko thabak se torpakanda maikoida ki halakpa dagi political interference lakpa ko ma ko namhatpa sumba ma ko lakpa sta madudagi ngakhoksana ba ko asopan yaulana maikoibu yani maningtamna ko with impartiality sumba while the people ngamandawi damakta maikoida zukra empowered to shield judges from political controversies. The constitution grants them immunity from criticisms against decisions and actions made in their official capacity. Adana masagi political controversies kaya dagi ngakthong naba judges simbuba constitution na kaidawa maikoida immunity immunity jing asagi koigi maikoida aso open ba thon da ba ni ko ngaklo wa da aso ngaklo ma maikoida awana ta na ba ko can be immune system have the type the immunity from criticisms against decisions and actions made in their official capacity. Judges na maikoina thabak tawringai ko manungda maikoina makha masagi official capacity da lawpa warefsin aduga official capacity tawpa thabak thorom singsi ko masida criticism pirakpa ko ayatpa pirakpa kanda ngasai madu constitution na maikoise madudagi ngakthole ngalo piyo ko The court is empowered to initiate contempt proceedings against those who impute motives to the judges in the discharge of their official duties. Aduga judges singna makoigi official duties ko mai mathau jingji tawringai marakta kaigumba makoida aranba misang mikhai naiba ko aranba bu sumannaba atraga sumbu lalanaba adugumba mawongi hataba ko agi sarau lang thalapana singba madugumba tawpakanda course-na haiba miyoidugi masakta masaigi contempt proceeding ka court pu ikai kumnadabagi adugumba action lokatpa yai tare. Even the parliament cannot discuss the conduct of the judge except when a resolution for his removal is before it. Aduna judiciary gi institution sita judges singbu kayamyamna immunity pibagi habagi wafam je lakpakanda India gi laiba lengar pathaba sida khwaidagi supreme body law making body amo oiba parliament haiba ko adugi mati saigi mamang su koina prime minister gi council of ministers ki cabinet ki ka naina kanda parliament ki role si am phasana pankre ko parliament se adugi mati mai check balance ke ka tong na mai power si am phasana lai haidana ko haiba judge amana tawpa thabak thoram yam sida ben parliament na fawda maram sadana khana naina ba yade judge amagi magi conduct ko magi thabak thawang singda karma matamda katang yabagi ha kanda when a resolution for his removal is before it parliament gi koigi house ta kanagumba judge amagi magi misbehavior or irregularities or abuse of his position and power sugumba ko partiality ki kari gi signal laktana saigi magi masakta impeachment tawna ba koigi moves koigi motion adamaina lakri pawda parliament of our judge amana oriba thabak tram sing matanga yengsin bagi rights later. Jurisdiction of the Supreme Court. Azikti Supreme Court ki magi jurisdiction se kari kari no habdoni ko Article 141 declares that the law laid down by the Supreme Court shall be binding on all courts within the territory of India. Asai India gi laiba territory si manungda laiba court kurema ka padagina High Court power gi marak sida laiba myam si sai gi Supreme Court na ka lepak pa ware aduna sai gi final way madu loina ma inlaga sakarawni. The different categories into which the jurisdiction of the Supreme Court is divided are as follows. As Supreme Court si mana the highest court of appeal ni, highest court of law ni, aduna Supreme Court na pai mathakta laibani na Supreme Court si gi magi tongan ba magi thabak tawbang ngambagi magi kayani bagi pangkai hadare pangkai si adugi mate magi makhan kya ama laire ko hariba myam si bagi khaidopa kanglup naina ko categories khaidopa kandida tongan ba kanglup oina khaidopa kandida Supreme Court ki jurisdiction si mari thongna pi original jurisdiction appellate jurisdiction advisory jurisdiction aduga for the review jurisdiction and jurisdiction makhan mari ni Supreme Court pi riziko aduna ngasigi class gi oina di oina hariba myam si loina koi cover to ngamde next koi class ta judiciary gi second part ko la pakanda atai koi cover to si high court ki service ko aduna ngasigi oina koi ahmada koi na lokatu si original jurisdiction gi wafam ni ko original jurisdiction na basi ngasai gi Supreme Court na magi tawya ba magi thabak thoram sing sigi ko pangkai haitare sidagi Supreme Court na tawya da ba High Court na tawida ba thaba adagi sessions court na tawida ba thaba na magi tongan ba keno sing khaidok nai adong sai magi tobom thopa magi thabak ai ba tar mathau dang sing ai tare ko wail ga mai leina ba madu ning sai original jurisdiction I see the Supreme Court has original jurisdiction initially as a federal court adana ahmada koina Supreme Court sing sai mamanga bullet point amada koi mamang slide ta ko mamang slides Mada koina panre. Supreme Court ki quite chawa magi role and function, important role and functions ba. Mayamdi marakta quite maru magi jurisdiction ama haragadi kaina kanda federal structure. The ila federal political system si masi ensure to writing aside madu nga nasat pangala. The union list, state list, concurrent list, and labels the central government ki magi power and risk automatic saw. So the provisions ke amada central government ki power si state government ki mathakta so yi ko magi kubam nungda ko state government ki kano se ko yi thambangami tabu magi federal ki Podcast yawani na federal political system jigi makhada ngasai state ki zuma ki tuma power khalai samna kana law and order ki wafam mai se ko state ki list sale ko state government na mai taw sabani ko adu ngasai ki high dina samaina ko union list state list concurrent list na lai da concurrent list se ko da moina ko concurrent list da yawi ko policy ngasai ki state na su state government na su taw ya central government na su taw ya in the larger interest of the people. Public interest, public welfare high concurrent list any item state na center na packet pay. Madrida aside Karigumba state ka center ka muna Bakanda Matamda central government nadum Matakta Maga Manang Sakal Lab adubu ngasai kaigumba kanda akoi ki state ki aduga center ki magi leiba magi power sharing ko mechanism ai tare magi center state ki relations da yenawa YSM saw thula masi kanza federal political system amase kaitharapagi akibu lai amdi central government Sita Odamni have a low innocent Ilalakta getting a state government ki magi power si Winama central government ki Makada Makata Leva subservient to the union government or central government. When a central government ki Makada state government is Laida the federal he can also among 13. A strong union government strong center ni aduga state sing si empowered to in magi constitution ki provision na adu state sinci center ke na kan de sole pa adu na sai india ki like federal structures se australia da na canada da usa da like federal structures ga kena ba myam like pa mai magi to ba lenga lo ni patha sa adu na high ba sugumba federal structures gi keno se kai thar ba gi aki ba se kanana nga ke ha kan the supreme court na nga ka Madugi Tudang as a federal court, Supreme Court in Magi, original jurisdictions. In a federal system like India, both the union and the state governments derive their powers from and are limited by the same constitutions. The other labor federal system, Sugumagi Makada, Lenga Patasi Makada, union government su state government sing su may exercise the powers may see kai the low gi have kanda constitution ni provisions in the biba magi union government at away aba the one number adugi ma'am the constitution ki provisions ma'am low at the same time masai union government at the one number what is the constitution yawi union government na towa yadaba toroidaba sagi thabaksing desu constitution yawi and both union government and state governments ki magi power se sagi constitution dagi lowi aduga mogi moina toroidaba mogi limitations sing so this is constitution yawi in matters relating to differences of interpretation of the Union states distribution of powers or conflicts between state governments and authoritative resolution by a judicial organ independent of both levels of government is required. In matters relating to differences of interpretation of the Union states distribution of powers, Union government aduga states government singi marakta distribution of powers, power sharing gi power se yena thok pai da re ba kana kana state na kari to ngam ngani adagi union na kari to ngam ngani ngam ha ba gi power si yen thok na ba gi wafam si la pa kan da masidam yet na ba muna ba thola ba or conflicts between state governments atragana state governments singi marakta say Kaveri water dispute ka Kaveri river gi singsi yanawe matanda South Indian states singi marakta conflicts like sugumba conflicts singse we tholapakanda an authoritative resolution by a judicial organ independent of both levels of government is required and state government su state government dagi su independent oiba union government dagi su independent oiba adugumba while losan while people ngamba haidare ma adugumba koi organ ma body ma mathau ta madugi waroisin from na wi ma adugumba authoritative resolution people ngamba je judicial organs oigadaune ko adugi da matani ngasai gi supreme court ki magi original jurisdiction se daida sigi union and states or center and states ki distribution of powers ko masigi or conflicts between states sigi matang stila paganda supreme court ki laws adugi matik chawa as a original jurisdiction. Under Article 131, the Supreme Court is given exclusive jurisdiction in a dispute between the Union and a state or between one state and another or between a group of states and others. And Article 131 in Makada, Supreme Court sina among the exclusive jurisdiction ko. Makatana to ngamba wayal se ko. Kari matanga Union government siga state amaga mugnarakpa. Natragana India gi state amaga atopa India gi state amaga mugnarakpa. Natragana atopa state singi group amaga atopa state singi group amaga hoi mugnarakpa suguma thorpa kanda Supreme Court na kata jurisdiction people na mi halogi keno sini Article 131 of PSC ko exclusive jurisdiction of the Supreme Court khatana ngamadoni exclusive jurisdiction of the Supreme Court means that no other court in India has the power to entertain such disputes. Similarly, the original jurisdiction of Supreme Court means that the parties to the dispute should be units of the federation. Original jurisdiction of Supreme Court na high vidhi kari no high kanda high ba any watho mugna bagi dispute ama thola pasida yaw godoriba koi party sing ka ai khana ba yawriba kaunul sing se mai koi si kedoba federation jigi units wai ramne union wai bi states wai bi state amaga wai bi a group of states against another group of states wai bi adi India gi laiba constitutional setup sida yaw magi federating units including the federal government. The Supreme Court also has an exclusive original jurisdiction as the protector of fundamental rights. Fundamental rights citizens in the fundamental rights executive mullaga natraga legislation mullaga bagi lakhidana bagi da madu ngaksen magi tharosisu exclusive original jurisdiction oina Supreme Court lai. Article 32 of the Indian Constitution gives citizens the right to move the Supreme Court directly for the enforcement of any of the fundamental rights enumerated in Part 3 of the Constitution. And then Article 32 na then Constitution the piri madudi citizen singna Supreme Court direct salaga aigi fundamental rights singna re adana masibu phangan liu haidana wakat payaya. As the guardian of fundamental rights, the Supreme Court has the power to issue writs such as habeas corpus, quo warranto, prohibition, certiorari, and mandamus. Now, this habeas corpus is a writ issued by the court to bring before the court a person from illegal custody. Habeas corpus Mandamus Servicina, writ issued by the court, may order the public officials to perform their legal duties. The official duty, public officials in the Mathau of the Banda, knowing Nathau was not all over the Tower Risna Mandamus. Prohibitions is the writ to prevent a court or tribunal from doing something in excess of its authority. Masai authority, one of the Tabak Topakanda, Madu Lepu, Towan, prohibit By the writ of certiorari, the court may strike off an order passed by any official of the government, local body, or statutory body. Masidana, Kosana, Sigi order says another yadi had an warrant is a writ issued to a person who is not authorized to occupy a public office to step down from that office. Masana authorized with Nataba. Public official, public office, Masi Adu office to be Mapunia than a man Masana Masa self style for settled the Aduma, you and Mabunang authorized with Bakan on a day, official not yet than Po Tabaki had in a Masigi Tower Recibuna Power and Tuana Korico. Adanasiana and the judiciary class economy, side the Thank you.